The International Criminal Court is now in session. Ludian Sarakol, Pinar International 8th Ward.
This was the last day of the oral submissions on the no case to answer motion, that penultimate moment when every party tries to present its arguments the best way possible to win the judges over.
This process, this building that we are in, is meant to administer justice. And this juncture of proceedings, really there's one question facing your honours. Is it pointless? Is it pointless, given what you've seen, the scrutiny with which it's been tested, to go to a defence case? Or do your honours have the right, and indeed maybe the responsibility, but certainly the right, to look at the evidence and say that no reasonable trial chamber could convict?
My understanding and my conception of the no case to answer motion is this: it is a limited, it is intended to be a limited and simple inquiry, as it were, to filter out those cases which are so obviously hopeless that there's no point in going forward.
But this is a very serious criminal case, very serious offence, and the defence counsel in it are taking it that seriously. And that's why it deserves and should deserve that level of attention to the detail.
At this stage, what is required is no more than just looking at does evidence upon which a reasonable trial chamber could convict exist. It's a question of existence rather than one of strength, if I may.
To me, evidence is generally mean that should prove some allegation. And do you think that it's even possible to call or to work with this term without looking at the quality or the strength of evidence?
It is not the procedure in these courts, as I understand it, that we should assess the guilt or innocence of the accused separately at the halfway stage and at the end of the case.
The defense teams insist the prosecution's evidence has been disintegrating and can no longer match the case presented during the confirmation of charges hearing.
But even assuming, Your Honours, that the defence have succeeded in persuading the chamber that there are contradictions or improbabilities or inaccuracies in the evidence of certain witnesses, it does not follow that the whole of the witness's evidence must be rejected as incapable of belief.
We ask that you apply your own standard, the standard of the Yugoslav tribunal, to the prosecution's test. No wonder they're running away from a critical analysis. No wonder they're saying quantum, not quality, because there's no quality. And for that reason, Your Honours, we do ask you to dismiss this case.
The exercise was what we wanted to see happen, and that is to give the parties full opportunity to address us, and we all look at the evidential matter together and discuss them. And the exercise has done what we hoped it would do, and we thank you all for your submissions. The proceedings are adjourned.
All rise.
It has been 4 days of a grueling legal battle inside the International Criminal Court trial chamber, with the defense teams bearing the burden of persuading the judges that the prosecution's evidence has been so hopeless or substantially insufficient to support a conviction, and therefore the case should come to a close. The judges are expected to give a notice on when to expect that highly anticipated ruling in due course. Sylvia Chebet, Citizen TV at the ICC in The Hague, Netherlands.